Gavin Buchanan and Renisha Goddard-Heath.
All right, folks, buckle up. This is one of those custody clashes where summer visitation goes from routine to courtroom chaos. Gavin Buchanan is about to air some serious grievances over a missed handoff with his daughter. Let's see how the judge untangles this.
Mr. Buchanan, I understand that this is your motion for contempt related to a July 14th episode where you alleged that you were denied visitation time with your daughter, Annabelle. So this is your motion. I'll hear from you first, and then I'll hear from Ms. Green.
Okay, so we had compromised on our summer visits to be 1 week on, 1 week off. And the first 3 to 4 visits went okay. And then randomly, the last 2 did not happen because Annabelle had been bringing some concerns to her mother's attention about maybe being left alone in my care.
And so what you're saying, if I understand, Mr. Buchanan, is that on July 14th, was that the start of your 1 week on, 1 week off time frame?
No, that was when the visitation started being denied.
Okay, so...
And just like that, we've got our key date, July 14th. Remember that. It's the line in the sand. Gavin says he was denied visitation that day. But the real question is, was it just a mixed dash up ... or something more intentional?
So on July 14th, tell me what happened.
I informed Renisha that I was going to be picking up Annabelle, and she told me that she was not going to be home.
Okay.
And I had arrived at the residence, and she was not there.
And was that your time to start your week on?
Yes.
Okay. What day of the week was that?
Friday.
Okay. And is that what you had been doing, that fifth on the week on, week off, exchanging on Fridays?
Yes.
Okay. All right. And then in your motion, just taking a quick look at it. Okay. So that was the main allegation I understood from your motion for contempt. Are there any other motion or other areas that you're alleging there was a violation?
In our parenting plan, there was supposed to be a mental evaluation for Renisha. It's never happened.
And did you type that out in your motion for contempt?
I'm unsure if it's in there or not.
I don't remember reading that, so that's why I ask.
Yeah, I'm not sure if it's in there.
Okay. All right. Anything else you want to tell me about the July 14th allegation?
No, just that the visitations were randomly stopped. I would like to know why.
Okay. So then on July 14th, when that visit didn't happen, when was the next time then did you have visitation?
2 weeks after that, and it was denied again.
Okay. All right. All right. Very good. Mr. Buchanan, I'm going to thank you for your input. I'll hear from Ms. Green, and then if you have any rebuttal, I'll have just a moment to share after Ms. Green's.
Enter the defense. Ms. Green's stepping in for the mother end. This is where the case takes a sharp left. Allegations of neglect. CPS involved a denied protection order. Yeah, this isn't just about missed weekends anymore.
Presentation.
Thank you, Your Honor.
Go ahead, please, Ms.
Yes, Your Honor. So Miss Goddard-Heath did stop visitation. She had heard concerns of the child's safety and father's care and had contacted CPS regarding those allegations. During the time that there was no visitation, there was an ongoing CPS investigation, and she was advised to seek a protection order, which she did. The protection order was denied because she hadn't presented enough information. It was continued multiple times for a hearing, but ultimately we dropped it after CPS had done an investigation with the child at Juliet House in Oregon, and the child had not discussed any of the issues that had been brought to the CPS allegations. So during that time, she had a legitimate concern for the child's safety. The child had made comments of physical abuse, neglect, and during the course of the CPS investigation, that was her advice as for what to do to prevent any harm from the child occurring. So that is the action she took. I believe that it was well-intentioned based on the concerns and allegations that were brought to her attention. And if Your Honor read my client's supplemental declaration, I apologize. I believe we sent bench copies of our declaration. We weren't aware that Ms. Goddard had filed one separately when we came on the case. And so I'm not addressing that at all because it was not, she obviously is not allowed to have two declarations in the court record. But speaking of the court rules, I also want to bring to the court's attention that Mr. Buchanan. I'm not used to having different names. It took me a minute. Mr. Buchanan also filed a declaration that far exceeded the page limits. If you looked at his reply declaration, it was both late. We received it only a few days ago. And also it was 23 pages of a written declaration in response to our client's declaration. So I would ask the court to exclude that for failing to follow the court rules. Additionally, the declaration is full of hearsay statements from CPS, other people, and comments made about what his partner had witnessed that aren't her written declaration. So I would ask that all that be excluded from the court's consideration since it's not legitimately before the court. But as I said, my client took reasonable measures because of the safety concerns for the child. Since the investigation has completed, visitation has resumed. And so she has taken the appropriate steps to protect the child from being in harm's way, given the recommendations from the state during that investigation period. So given that the motion for contempt was only for the date that Mr. Buchanan brought to the court's light, where we would ask that the court deny contempt. There was nothing intentional or willful to harm Mr. Buchanan's visitation. It was solely for the safety of the child, given the allegations that had come to light at that time.
Okay, pause right here. Now both sides have spoken. Gavin claims visitation was unfairly cut off. Mom's team says they had legitimate safety concerns, but CPS didn't find anything concrete. So what happens when fear clashes with facts? That's exactly what the judge is about to weigh in on.
Ms. Green. Mr. Buchanan, just a brief rebuttal.
So I had also talked to CPS, and they had informed me that nothing was said to Renisha regarding me being able to have visits with her.
Tell me what that means.
So CPS had not informed Renisha to stop visitation at all.
Oh,
That's
okay.
what CPS had told me.
Okay. All right. Thank you. Okay. So here the allegation is that the parties were engaging in following the parenting plan, which called for basically a 50-50 plan during the summer, basically week on, week off. And that the allegation was that Mr. Buchanan was driving to pick up the child, and an hour from the pickup, the mother canceled and said it's not going to happen, and it didn't happen. So then in response, Ms. Goddard Heath indicates that she had some concerns related to the child being left alone and threats allegedly made from the father to the child. She brought a no contact or a protection order that was eventually denied. And there's also a child abuse, kind of a formal interview of the child, and there were no disclosures made at that time. So clearly there was a denial of the visitation. Then the question becomes if that's a reasonable step given the circumstances. So the allegations here were that the child was left unsupervised for a period of time. The response to that was that the stepmother was present outside washing a car, had the baby cam on, and was supervising. There was indications that potentially the children were there alone, and somebody rang the doorbell, which frightened the children and the like. So, and then there was an allegation of a threat. A threat of physical harm. So in some instances, I think that there is oftentimes it is reasonable to suspend a visitation. Here, I don't find that that was reasonable, especially given the fact that the protection order was denied and that there were no disclosures. So I'm going to grant the motion for contempt.
And boom, judgment drops. The court does find mom in contempt. That's a serious ruling, folks. Translation: the court believes the visitation denial wasn't justified enough to break the parenting plan. This is a big win for Gavin, but wait, there's more.
Against Ms. Goddard Heath and order a makeup time to occur at a time of the father's choosing. It has to be a reasonable period of time. My first thought would be that it would be next summer, but that may not be feasible and maybe kind of be lost in the passage of time. So we'll talk about that in just a moment, and I will order Ms. Goddard Heath to pay $40 of gas for the expenditure of the time, expenditure of the gas money to get up to the visit that was denied. So, Mr. Buchanan, do you have a time frame that you're looking at as far as makeup time?
The only thing I can think of with her being in school right now would be every weekend until the time's made up.
Okay, so that would be a Friday, Saturday, and Sunday, so roughly 3 days and one overnight of 2 overnights. And so that would be over a period of 3.5, or 3 to 4 weekends, correct? My calculations are right, 7 days.
Yeah, and the thing is, we already do every other weekend right now.
Okay. Ms. Green?
Obviously, I think my client would be concerned about losing every weekend. I mean, we can add 1 weekend in per month to make up the time. It obviously will make up the time. I would ask that my client have priority to pick the weekend in case she has any activities or events with the child, though, because they've already been following it every other weekend. So I don't know what activities and so forth are scheduled at this point. So rather than having father pick which other weekend per month, I would just ask my client be able to decide.
Okay, so I think I tend to agree that the makeup time should not be, just like all in a big burst here. So I think it should be 1 additional weekend per month in October, November, and December, and there'll be a little bit of carryover into January because we'll have, I believe, so we'll have the Friday, Saturday, 2 overnights in October, November, and December. That would be 6 overnights, and then there would be a 7th day in January. So I'm thinking that should be the last weekend in October where there's not right now a scheduled visit to the father for Mr. Buchanan. So, Mr. Buchanan, what's with the alternating schedule? Where are you at right now as far as when's your next visits planned for?
So I was supposed to pick her up this Friday, but due to funds, I'm not sure if I'll be able to pick her up this Friday.
Okay, so that would be your next one. That would be on the 7th, and then you'd be picking up potentially on the 21st, which is the next, or the 20th, which is October. That's the next week. So potentially the 27th would be an additional makeup weekend.
Okay.
That'd be the last October or last week of October.
And my only concern is that's the weekend before Halloween. Usually any school carnivals and events and so forth generally happen with the child may already be committed or participating in. I hadn't talked to my client about future visits yet, so that'd be my only concern. That's why I'm asking that my client be able to pick additional weekends. So we would prefer next weekend. And it's also concerning, I would say, that father isn't exercising his visit now that he's planning on having this weekend. He just let the court know. So I don't even know if these makeup visits will occur or not.
So what I'll do, I'll order that the makeup weekends occur the last weekend of each month. If the parties come to a different agreement based on the schedules of the children and the like, then that they can agree to that. But if they cannot agree, then it'll be the last weekend of October, November, and December, and then the last week in January for that 1 additional day.
Okay.
So, Mr. Buchanan, since you prevailed in this motion, generally we have the prevailing party draft just a brief order that describes what the court ordered today, and then distribute it to the parties and to the court. and then we would set a date to review it. Is that something that you think you could do?
Yeah, it's something I could do.
Okay, let's set a presentation date. We'll take a look at, that would be, how does the 17th of October look for the parties?
That's fine, Your Honor.
Okay, Mr. Buchanan?
That works for me.
Okay, so Mr. Buchanan, if you can get that order out to Ms. Green by no later than next Tuesday. Actually, if you can get it to her by Monday, the 9th, and then she'll have our opportunity to supply any objections, and then we'll be here on the 17th.
Thank you, Your Honor.
Okay. All right. If there's no other issues, that'll conclude that matter for today. Any additional items, Ms. Green?
So what did we learn today? Courtroom crew. In family court, even with emotions running high, procedures matter. If you're denying visitation even for safety concerns, you need concrete evidence, not just suspicion. Otherwise, the law steps in and contempt comes knocking.
No, Your Honor.
Mr. Buchanan? Okay. That'll conclude the matter. Thank you.